Are you sure?
Here's the 30-second lesson on what legends know. Never ask a bride why she's getting married. Don't wear a skirt on a windy day. Deodorant is not a shower. Don't sniff chili flakes. And don't forget, saving is not investing. Legends don't just save, they invest in mutual funds. Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
7-judge bench of the Supreme Court has delivered what is being seen as a landmark judgment. Landmark judgment on subcategorization of scheduled castes and scheduled tribes, or let me put it more accurately, subcategorization within the scheduled castes and scheduled tribes. And this, they say now, that this is the power that both the central government and the state governments have. What this means is that suppose 15% seats, 20% seats, X number of seats or positions in any place are reserved, say, for one category, that is scheduled castes or scheduled tribes. Within that, instead of treating it as a whole, the central government or a state government can say that, okay, of this much, if 15% of the total seats, say, is 30 out of 200 seats, then of which 10 will go to such and such community, but that community or caste shall be from within the already notified scheduled castes or tribes. That is the simplest possible explanation of this. Now, I know that because of this, there is a lot of speculation. There is a lot of misunderstanding. There are apprehensions. There are also wrong conclusions being drawn on both sides. On the side of those who want more reservations and who want more in the name of social justice, also wrong conclusions are being drawn, wrong fears are also being drawn by those who may be opposed to reservations or who might see expanding reservations as a threat to them by way of their share of what is a limited pie. Every pie is limited. That's the reason it's important to understand what are the main things that this judgment will make possible and what are the things it will not make possible. So first of all, because a lot more of the debate, the burden of the debate has been what are the various things this judgment will do, which actually it will not do. That's the reason I am listing what it won't do first, 5 points of what this judgment won't do, because those are the ones being debated and also quote unquote feared, and then 5 points of what this judgment will do. And then I might tell you a couple of things about the implications this will have politically almost on an immediate basis. So let's go there at some point of time. I will not be so disrespectful as to not mention to you the names of the lordships and also who agreed, who disagreed, who wrote the judgment. There are 3 different orders in this one. It's a 7-judge bench, I told you. 6:1. 6 have given the majority judgment. They are on one side. 1 judge has dissented. I will give you all the names as we go along, but so as not to clutter the very early part of this episode, let me first list the 5 things this will not do. The 5 things this will not do are as follows. Number 1, this will not lead to any increased reservations for any category anywhere, either centrally or in a state. This does not mean that if the scheduled caste quota is this much percentage, now it will go up, or if scheduled tribe quota or OBC quota or economically bigger sections, although that is not relevant in this particular case, all of that will not change the maximum limit to reservations that the Supreme Court has already laid down does not change. This judgment will not change any of that. So that one apprehension should be set aside, that this will now lead to a mad race for more and more reservations, putting more and more positions under reservations. That's not happening. Whatever will happen within what is already provided for in the reservation quotas right now. That's the first point. Second, the existing scheduled caste and scheduled tribe lists will not be tinkered with, at least not as a result of this judgment. So what this means is, again I see an apprehension that, with this judgment, now states can say so and so is not scheduled caste or so and so is scheduled caste. That can't be done. that can only be done by a presidential notification. That's a legislative action. This judgment does not give any direction there, and certainly this judgment does not give any directive or order there. So the lists of scheduled castes and scheduled tribes as these exist today will remain the same. These will not be affected by the judgment. So that is the second thing that will not happen. That will not happen as a result of the judgment. Number three, no state can exclude any caste notified by the president, nor include a caste not notified by the president as a result of this judgment. Now, this draws from the point we just made earlier that new scheduled castes and scheduled tribes cannot be created as a result of this. So this judgment will also not empower any state. It empowers the states to create subcategorizations within the reserved jobs and seats for categories duly notified already by the President of India up there on Rashtrapati Bhavan for scheduled castes and tribes. No state can use this judgment to exclude any community notified by the president in any category or to include any that the president has not yet notified. That needs great clarity. We have to understand that. And the next point with this, there will be no impact on the current reservations in UPSC, IITs, IIMs, NEET, JEE, etc. So first of all, if a state makes a change in these categories, if the state says, look, I have 15% or 20% reservations for such and such category, now I think that too many of these positions are going to the dominant caste within a scheduled caste. So there are really backward, poor scheduled castes. I will use the example because the Supreme Court judgment uses it, Justice Chandrachud uses it. People who come in from scavenging castes, they are subjected to much greater discrimination, untouchability than those, say, engaged in weaving. These are the two selections that he has made, right? So a state can make those distinctions. Even if a state makes those distinctions, that will not apply to any of these central positions. So no UPSC, no IITs, no IIMs, no NEET, no JEE, unless of course the center decides to use this judgment and make the same adjustments. It's very unlikely because somebody is in power in the center, and whoever is in power has to run politics. So they can't take the risk of annoying one community here to please another community somewhere there, right? Because these things are all interconnected. But it's not impossible, but no state government can make any changes the state governments make as a result of this judgment will not affect UPSC, IITs, IIMs, NEET, JEE, etc., QET, everything else that is there. And finally, the fifth point, the judges have said, and this has got a lot of the headlines. 4 of the 6 judges who are agreeing on this order, and I will tell you how this order came in, we'll get there in a couple of minutes. 4 of the 6 judges who are on one side, they have held forth in great detail about the need to exclude the creamy layer or defining the creamy layer. If I have already become a judge of the Supreme Court of India, I'm using that very notionally, right? So I've got my privilege, right? Should my children also get the benefit? Or I've become the President of India, as our President is. I'm a tribal. Should my family also get benefits of reservation? Should I not be in the creamy layer? That's a question on which 4 judges have spoke, and that's been discussed very much. Remember, this makes no difference. 0 difference, because this is not binding, this is not a direction, this is not a directive. This is just a case of the judges thinking aloud. This is a case, once again, of judges, each judge writing their own editorial article, their own op-ed article, saying this is what I believe, this is what my opinion is. But this is a personal opinion, this is not binding. So a creamy layer business is not being brought into the SC/ST reservations as a result of this judgment. We have to understand this. This is a very important point, particularly because of the amount of time and energy and the emotion the judges have invested in talking about this. In fact, if anything, I will slip in a little opinion and say that judges sometimes get too tempted to hold forth on things like this. And while they are entitled to their views, maybe they can express these views in public speeches and places. But to put this in the judgments, it makes it that much difficult for judgments to be understood. It leads to misconceptions, propaganda, and also, not that the judges have to bother about it, it makes the job of people like me that much tougher, right? Because then you have to see what is really all this chaff and what is the grain and what is it that matters and what is it that doesn't matter. And you can imagine that in such a vast judicial system, in some court, someplace, I don't want to say high court, trial court, some court, in some court, someplace, somebody without having made a proper reading will draw a wrong conclusion, and that will then end up where everything ends up in the Supreme Court of India. So basically, some of this editorial writing which is not leading to an order, any logic justifying the order is fine. You can take your time, you can describe it at length, quote case laws, but anything that is not really relevant to your order, it's best to keep it short or to exclude it, say it in public speeches. There are enough opportunities for judges to give public speeches now, or to learn from what UPSC used to have, at least earlier, I don't know, it still has now, an exam in pressy writing. So write a little pressy, right, and give your views. Otherwise, it's very confusing. So once again, the fifth thing that will not happen as a result of this judgment is the empowering of any state or central governments with creating creamy layers within the scheduled caste and tribe categories. So that has to be understood. Now, what are the 5 things that this judgment does? These 5 things are: number 1, it authorizes the states and the center to subcategorize castes and tribes already listed under the scheduled castes and tribes. How this works is, once again, using Justice Chandrachud's example, the lived experience of scavenger caste and the weaver caste or the cobbler caste, leather workers caste, Jatavs, right? Lived experience of all these castes, the larger experience is discrimination, untouchability, but within that there are variations. So a state government can address, or a central government can address that diversity by creating sub-reservations within the same reservation. So if there are 90 jobs available, they can say 10 are reserved for this category, which means all the rest will compete for the remaining 90 categories. What the court has said is unconstitutional, on the other hand, or will be unconstitutional, if you say that I believe that of these 10 castes which are grouped under scheduled castes in my state or nationally, these 2 are extremely backward or they have faced extreme discrimination, they will get preference across the board. So there is no preference across the board. There is no, I will give 10% extra marks across the board. Nothing like this, because that can lead to, theoretically, those categories taking all of the jobs. If that is done, the court says it will be unconstitutional. However, any state government or the central government, if they so choose, can create subcategories within castes and tribes as listed in SC/ST lists. Number 2, once these subcategories are created, then these subcategories can be given reservation within reservation for the larger categories. So if UP, for example, which is quite likely because that's the politics of this, the politics of this will be that in a state like UP, where Jatavs have voted by and large with Mayawati, and BJP has been targeting the Valmiki and other votes, it's quite possible. I don't think they will do it. It will be poor politics for them because they want all scheduled caste votes everywhere. They're competing with Congress now. But it's quite possible, it's plausible that UP might say that within the scheduled caste reservations in the state, we are reserving so much for Valmikis and others. The same game that Nitish Kumar has already played with Mahadalits in Bihar. So there are Dalits, Mahadalits, they are all scheduled castes, but some have faced more discrimination than others. So states can do that. That is the second point. First, they can make subcategories. Second, they can give a part of the already reserved positions to these subcategories. Number three, the court has said that for all scheduled castes, backwardness is presumed. So tomorrow, nobody can say that, oh, so and so scheduled caste has now moved ahead, so they are not backward anymore. For all scheduled castes, backwardness is presumed because that is the lived experience for millennia, and that is not going to change suddenly, and that is what indirectly also addresses the creamy layer issue, because once you link backwardness to caste and lived experience, then to tinker with that based on the creamy layer principle is going to be that much tougher. Number 4, this can be used by any party in power to create separate vote banks within the scheduled caste and scheduled tribe groups. Say Meghalaya, for example. Meghalaya is a tribal state, but Meghalaya has political divisions among tribals. So the Garo tribes, which are one part of Meghalaya Hills, the Garo Hills, and the Khasi tribes, Khasi Jaintia tribes, the other side of Meghalaya Hills, generally they followed different political trajectories. Generally, Garos have leaned towards a national party. They've been with the Congress for a very long time. The current chief minister, ruling family of Meghalaya, chief minister, home minister, etc., they are from the Garo tribes, right? Tomorrow, somebody could say, all right, within my tribes, my scheduled tribe reservation, I am creating this many more for this category. This is a very crude example because I've used a tribal state, but you can do it in a state like Rajasthan, or a state center could do it between the tribes, saying that one particular tribe is getting a lion's share of all reservations, particularly in UPSC. So I can't take away their right over competing because they are a scheduled tribe, but because in the process I think some of the more backward tribes get left out, so I am reserving 10% of, say, UPSC or any seats for tribes from Santhal Pargana or Bastar or Arunachal Pradesh or anything like that. Those things have now become possible. And finally, this draws from the previous one. Parties can now use this judgment to address their constituencies. So their constituencies means some subcaste, some scheduled caste, particular scheduled caste, saying that, look, you got this reservation, but I get nothing. All of this is taken by the dominant caste, dominant scheduled caste, or dominant scheduled tribe. So I am left with nothing. So the politicians whose constituents these people happen to be, they can then say, I take it, I accept it, I've got this data. Now they will have to find data. The judgment also says that this can't be arbitrary, that governments, when they take this decision, will have to find data. If they find data, they can create special dispensation within the same quota for their constituency. So this is really quota within a quota. So quota doesn't expand, quota doesn't go away, new people don't come into a quota, but for those entitled for a quota, this provides the power, this gives the power to the state governments and the central government to create quotas within quotas. That is the essence of this very complex orders which 7 eminent judges have delivered. D.Y. Chandrachud, the Chief Justice, he wrote the order for himself, and Justice Manoj Mishra, then Justice B.R. Gawai, Vikram Nath, and Justice Satish Chandra Sharma, all on the same side, and Justice Pankaj Mittal. All of them are supporting this judgment. It's 6:1. They've all written separate judgments. That's the reason I said it's a lot of reading. And then Justice Bela Trivedi has dissented. It's also important to see why they've dissented, because very often in these multi-judge benches, what the dissenter says becomes as important as what the agreeers have said. And her dissent is, number 1, she says that the route through which this case came up to this 7-judge bench, that route is wrong. I mean, I can use the expression vitiated, but she hasn't used it. But the implication is that route is vitiated simply because this case had come before a 3-judge bench. This had come before a 3-judge bench, which referred it to a bigger bench, a 5-judge bench, which in turn referred it to a 7-judge bench. That's because underlying this was an order of 2004 by a 5-judge bench. Ultimately, what's happened now is that a 7-judge bench has set aside that order of the 5-judge bench. I will tell you a little bit about that as we go ahead. So she said a 5-judge bench, that was because a state came in appeal, Punjab came in appeal against that order saying this should not be applicable to us, right? That 3-judge bench gave it to a 5-judge bench and onwards. And she said that 3-judge bench, the order of the 3-judge bench giving it to a 5-judge bench and escalating it was cryptic and perfunctory. The second area where she disagrees in principle with the majority judges say that between the scheduled caste and scheduled tribe communities, there is heterogeneity, right? So you can classify them in different classes because their lived experiences are different, discriminations they have faced are different, etc. She says, on the other hand, that scheduled caste and scheduled tribes are homogeneous categories. They are not heterogeneous, and so these categories can't be tinkered with. So how we came here is that let us say that this started in 2000. This started in year 2000 in Andhra Pradesh with Chandrababu Naidu. So Chandrababu Naidu it is, as Chief Minister of Andhra Pradesh, who passed a law, that is Andhra Pradesh Scheduled Caste Rationalization of Reservations Act 2000. In that act, he created 4 categories. He divided the scheduled castes in 4 categories. Remember, that is something that the BJP was talking about during the recent campaigns in Telangana, I think, when they were talking about creating a special dispensation for Madiga community. So Chandrababu Naidu's law divided the 15% reservation, 1-5. That's the base. 1-5, that's the cake or that's the halwa, right? That's the key word these days. So this halwa of 15%, he divided as follows. 4 categories, A, B, C, D. 1% for A, 6% for B, 7% for C, and 1% for D. So 1 plus 6, 7, 7 plus 7, 14, and 1, 15. So that is how this cake or this pie or this halwa was to be divided. 1 plus 6 plus 7 plus 1, that is A, B, C, D. That's how they divided it. That was challenged in Andhra Pradesh High Court. It was challenged in Andhra Pradesh High Court, which upheld it. A 2-judge bench of Andhra Pradesh High Court upheld it. It was in turn challenged in Supreme Court. That is the law that was struck down by the Supreme Court by a 5-judge bench of the Supreme Court. And I shall tell you the names of those judges, eminent judges: Justice N. Santosh Hegde, Justice S. N. Varyaba, Justice B.P. Singh, Justice H.K. Sema, one of our rare tribal Supreme Court judges, and very eminent judge, a wonderful human being as well. So Justice Santosh Hegde, Justice S. N. Varyaba, Justice B.P. Singh, Justice H.K. Sema, and Justice S.B. Sinha. So they struck down unanimously the Andhra Pradesh law. Now, while this was going on, there was a 2004 Supreme Court order striking down the Andhra Pradesh law. Undeterred, Punjab government, this is Amrinder Singh's government, he's under pressure. This is before he lost his election. Amrinder Singh's government in 2006 passes Punjab Scheduled Castes and Backward Castes Reservation in Services Act of 2006. And that then divides the reserved categories, the reserved seats between Balmikis and Mazhabis, 50%, right? So 50%, 50%. As he does his 50% division, that is also challenged. That is challenged in the Punjab and Haryana High Court, where a 2-judge bench strikes it down. And on what basis do they strike it down? They strike it down based on the 5-judge unanimous order by the 5-judge bench of the Supreme Court, striking down the Andhra Pradesh law, saying the same order should be applicable to this also. They strike it down. In appeal, Punjab government went to Supreme Court saying that the Andhra order, or the E.V. Chinaya order as it's called, did not apply to them. And while all of this is going on, 2009, M. Karunanidhi is still there in Tamil Nadu. He also passes a law, and I will read the name of the law. It's a bit long, so I will try and read it slowly. This law is Arundhatiyar Special Reservation of Seats in Educational Institutions, including private educational institutions. That's important. Educational institutions, including private educational institutions, and of appointments or posts in services under state with the Reservation of Scheduled Castes Act of 2009. Now, Arundhatiyars are particularly backward and deprived section of the scheduled caste community in Tamil Nadu. They are like, in a way, it's old scavenger community. So he made a special section in the overall reservation for them. That was also under challenge. The impact of this judgment is that all these laws, the Andhra law, the Punjab law, and Tamil Nadu law, they've all effectively, at least in principle, they've been reinstated. And similarly, other states can also now pass similar laws. While for clarity, the Supreme Court has not said that all these laws are reinstated, but I'm saying in principle, because the principle has been established, the laws that are based on this principle, these will likely be justified in continuing. I suspect each state will come to the Supreme Court now for a validation. However, I told you earlier there will be some political implications of this. So one will be that immediately regional parties, it will be easier for caste-based parties because these castes vote for me, these castes don't vote for me. So either they can do more for the castes that vote for them, or they can try and do something more for the castes that might be sitting on the margins. Kabhi isko vote diya, kabhi isko nahi vote diya, right? Or nationally, a party like the BJP plays this politics within the Dalit community. Playing politics within any community is perfectly legitimate politics. It's perfectly morally correct politics. Everybody does it. So in Uttar Pradesh, they've tried to wean away the non-Jatav Dalits from Mayawati in the past, right? This time they might have seen that some of them have gone back to the Congress party. So there'll be a temptation to do something about that. The second thing that will happen as a result of this, and that's very significant, that because the judges say that you can make these changes, but you can't do this without any data. So you need data and evidence. Where will the data and evidence come from? That will come from, you guessed as well as I guessed, the demand for a caste census will now become even stronger. That you might say that all of these are scheduled castes in this state, but you need a census to determine that within a scheduled caste, who is which caste and what is their status, etc. So that these will be the first immediate political implications of this landmark order.